a lot of academics, and I'm keeping this in that space, have seemed to agree with the ruling of the Supreme Court, acknowledging they are sticking with the letter of the law. There are those who have disagreed and said there should have been a purposive interpretation, but they sticking with a literal translation of the law seems to have gone down well with quite a large section of academia. You, however, hold a different opinion. What are your points of divergence?
Well, thank you. There are many, in fact. The only thing I like about the opinion is that it's well written and it is timely. Beyond that, everything about the opinion is, in my opinion, flawed. Look, even if you wanted to take a literal interpretation of the Constitution, you wouldn't have gotten the result that they got, because the most literal reading of the Constitution is that the Speaker does not have a casting or original vote. And then you go to Article 295(2)(a), and Article 295(2)(a) basically says, look, when we refer to somebody by his office, then everything that applies to that somebody would apply to somebody who is acting as a deputy or assistant in the same function, in performing the same function. So when you read the Speaker does not have an original or casting vote, it also means the Deputy Speaker does not have an original or casting vote, or any member presiding, because as long as you are playing the function of the Speaker, then you don't have an original or casting vote. So that is the most literal interpretation. If you wanted to read the Constitution holistically and apply it literally, you just look at the article on what the Speaker can do and cannot do, and then you go to Article 295(2)(a), and the issue is resolved. But you can do even better than that, because I believe when you are interpreting the Constitution, what you are trying to do is to try to understand what was driving the people who wrote the Constitution. If you did that, then you go to the legislative history. And if you go to the legislative history and you review where we came from 1957, in fact, in 1957, there was a specific language in our Constitution which says a deputy speaker retains his original vote, but he doesn't have a casting vote. And that particular clause, the deputy speaker retained his original vote, was passed as an act in 1965, Act 300, repeats the same thing. So when we have the Constitutional Commission, the President Akufo-Addo, not the current President Akufo-Addo, but his dad, he presided or chaired the commission that proposed articles for the 1969 Constitution. They proposed that we retain the language in the 1957 Constitution about the Deputy Speaker, as well as the 1965 Act. And that proposal was considered by the Constituent Assembly, and the Constituent Assembly explicitly rejected that. And the same thing happened in 1979, and the same thing happened in 1992. That is why the Deputy Speaker language that gives him an original vote disappeared from our Constitution. So when you use what we call the subjective purposive approach, that is what is in the mind of the framers, the inescapable conclusion that you come up with is that somebody presiding does not have an original vote. Then there's also what we call the objective purposive approach. In other words, when you look at the values of the Constitution, what exactly is the prudent and optimal way that we organize ourselves? In that realm, you tend to see that whoever presides as a speaker, even though he's a member of parliament, wield substantive authority over other members. And that authority that he wields is coextensive with his being impartial, at least in appearance, given that power that he temporarily holds as the speaker pro tempore, then it is expected that he would not be able to participate in the debates like an ordinary member or vote like an ordinary member. So on that objective, purposive ground as well, you reach the same conclusion that the deputy speaker does not have an original vote. Then you can look around the world like the Supreme Court tried to do. They looked at Kenya, they look at Botswana, they look at UK, they look at Canada, they look at Australia. And when you put it all together, the trend worldwide is that somebody who is presiding is not given an original vote. And so that adds to the proper conclusion being reached, which is a deputy speaker does not vote. Now, these are all analysis. Let's also just look at even the practicality of the ruling. Number one, you say that the deputy speaker must be counted in the quorum and can vote. Let's just go to the voting. What exactly is the voting that he's talking about? He says he must take part in the decision. Well, that is so broad that it doesn't help me. Parliament makes so many decisions. Everything that Parliament does is a decision. Is the Supreme Court saying from now on, every decision that Parliament would have to make will have to meet a quorum for voting? That is impractical. That almost is a court that doesn't understand how parliamentary works. One reason why Justice Sowa says when it comes to Parliament, their laws are aliens to the court, and the court step aside from trying to rule over what they do. Number two, even if we grant that there's a decision that has to be made and the deputy speaker should take part in it, well, how does he take part? Most decisions in the Parliament are made by voice vote. Is the Supreme Court saying that the person who is presiding, who is supposed to be paying attention to the yeas and the nays and deciding whether the yeas and the nays have it, should wear an MP hat and also be shouting yay while he's still listening for who is the loudest? That's impractical. And if the deputy speaker cannot take part in the yea versus no vote, and a division is called, a division is like a recount. If you did not take part in the preceding voice vote, you are not allowed to take part in the division, because the division is not a new vote. It is just somebody complaining that the voice vote was not properly counted, and so let's go to a division. And so a deputy speaker who did not take part in a voice vote cannot be said to be taking part in a division.
But Prof, just to what then becomes, I understand the point you are trying to make, that the Supreme Court perhaps should have looked at the logic of how does somebody who's supposed to be, so the impartiality of the person presiding is what should have held sway. But then the question of representation also comes in this regard, where those who support it then say, what becomes of the ultimate objective of representation of somebody who has been voted as an MP? And for the purposes of our constitution right now, the deputy speakers are both sitting MPs. Where then does their ultimate obligation of representation go? Why should they lose that simply because of the fact that they have become a deputy speaker presiding?
Because it is really a stretched point. Now, we are talking about a parliament that is going to make thousands of decisions, and there are very few cases when a deputy speaker is presiding. Mm-hmm. And so when you look at the number of cases that will be implicated by this presiding of a deputy member, and weigh it against the value of impartiality, it is not even a contest. Number two, the deputy speaker wields other power even when he's not presiding. By reason of being a deputy speaker, he chairs so many committees. So people from a constituency that have a deputy speaker actually ends up benefiting than those from constituencies who do not have a deputy speaker. Now, when you look at the constitution itself, the constitution disqualifies a member of parliament if the member of parliament has a contract that is being considered by parliament or has an interest in a contract that is being considered by parliament. The constitution says, well, you cannot vote. Well, why? Isn't he representing a constituency? If he's representing a constituency, why should that whole constituency be disenfranchised, to use your term, merely because the MP himself or herself does not have a vote? Look at ministers. We appoint a lot of ministers from parliament, and the implication of being appointed as a minister in parliament is you are almost like a part-time MP, because most of the time or half of the time you are not even in parliament. I don't hear constituents complaining that, hey, we sent our MPs there to go and represent us. Why is he up there as the North Regional Minister or as the Gender Minister, and so on and so forth? I think this is one of the most exaggerated reasons that you can think of. It has no basis as a constitutional matter. It is just brought in. It's a political argument. It's not a legal argument. So that makes no sense whatsoever.
You've also expressed dissatisfaction with Parliament itself not being allowed to make representation at when this case was being heard by the Supreme Court. I've also heard those who say, well, Parliament was aware, the Speaker had addressed this issue and in fact had said on the floor of Parliament that they were all awaiting the ruling of the Supreme Court. And so they should also have known that, well, if this is what is happening, perhaps we can also go in and tie ourselves in to this case. So why blame the Supreme Court for this?
Again, that is not a legal argument because, number one, everybody understands that courts should not try people or institutions or body in absentia. If you are going to make a decision that affects somebody's interest, at a minimum, you have to hear what that person has to say. So that is a fundamental concept that nobody has to argue with. We accept that as a matter of equity and as a matter of justice. Number two, our courts have held time and again that a person who is not a party to a litigation cannot invite himself to the dance. In other words, unless you are the plaintiff or you are the defendant, you cannot go to the court and say, court, I want to take part. The only people who can join a party is the party itself and the court on its own volition or on its own motion, what some people call the court suo motu. So even if Parliament was aware that this was going on, Parliament had no basis or path to invite itself to the proceedings. It was up to the court to look at the issues and decide that the equities of this case, for full justice to be done, considering that the Attorney General, who normally represents state institutions, have an interest that is adverse to Parliament, then we want Parliament to be heard. More so, Parliament is not just anybody, but it is a co-equal branch of government. So as a matter of institutional committee alone, the court should have invited Parliament to be heard. And if the court invited Parliament to be heard, many of the mistakes that are in the ruling would probably not have arisen. For instance, decision made. One of the issues is whether the deputy speaker has to be counted in the quorum for decisions, or can take part in the decisions. Such a broad issue, no reasonable court will answer such a broad issue. You have to be a little more specific, because decisions are so wide that if you give a general ruling that the deputy speaker can be counted in the quorum for a decision, does that mean if we are making a decision as to whether or not we should approve yesterday's the minutes of yesterday's meeting, there should be a quorum and the deputy speaker should be counted? I mean, that doesn't work. Now, let me also indicate the conceptual flaw in the court's biggest argument. The court's biggest argument was the difference between Article 102 and Article 104.1.
Yes.
Now, Article 102 is the quorum in Parliament, and Article 104.1 is the voting in Parliament. If you don't understand what I just said, then you will go the path of the court and make all types of mistakes. The Article 102 quorum serves two purposes. Number one, it tells us the minimum turnout of MPs before business of the House can commence. That's number one. And that minimum turnout, given the current number, is 92. Second, and more important, it tells us who is eligible to be counted when we are determining this quorum. And in that, it says anyone presiding cannot be counted, because the quorum, the counting, is only of the floor members, the people actually on the floor who can do business. So that establishes that anytime we have to count for purposes of determining a quorum, if a member is presiding, if a member is wearing the hat of a speaker, he cannot be counted. So that's Article 102. Then you go to Article 104. Article 104 has a limited use, because it is saying that what should happen in the business of voting. In the business of voting, it basically says in the business of voting, number one, we are going to consider an issue as accepted or as prevailing if 50% plus one of the people who are present and voting vote for the issue. Number two, in order to avoid a situation where a minority group is oppressing a majority group, the minimum turnout for purposes of voting is going to be at least half. That is 138. 138. It doesn't say anything about who should belong to the 138. No, the voting in Parliament doesn't talk about eligibility. It just talks about turnout and the decision rule for making decisions. Now, who do we count when we are considering this question of who can vote? Well, you go back to the article on quorum in Parliament, because you are making a decision as regard quorum in Parliament. That is why 104 says that, except as stated in this Constitution. So it's reminding you that relate back to 102 when you want to know who should be counted. And if you go to 102, 102 resolves that the deputy speaker is not counted. Look, it is very similar to this whole question of a referendum. When we are going to have a referendum on creating a region or something like that, if you look at the article relating to the referendum and deciding whether the issue has been carried, it gives you some threshold. It says, well, number one, at least 60% of the people must show up, and number two, of the 60% who show up, about 85% must vote before the issue is carried. That is the only purpose of Article 104.1. It tells us the minimum number of people who should be there before we can vote on an issue. And then number two, once we vote, how do we determine whether or not the issue has carried. It doesn't say anything about who is eligible to be counted. To know who is eligible to be counted, it has to go back to Quorum in Parliament, Article 102. The court completely misunderstands the architecture and then somehow says, because the 102 says that the deputy the deputy speaker or the presiding member cannot be counted, but 1041 doesn't say the deputy speaker cannot be counted, then it follows that the framers did not care whether the deputy speaker was excluded from deliberations, but they wanted the deputy speaker to vote. This is complete. I mean, I'm flabbergasted by that line of reasoning. It's completely flawed, illogical. There's no saving grace to that line of thinking, especially when there's an easy way to resolve this question by looking at Article 295 2A, which says anybody performing the functions of the speaker should be treated as the speaker himself. So all the respect that you give to the speaker, give to the deputy speaker when he wears the hat of the speaker. If the speaker cannot vote, you, the person presiding, cannot vote. So I'm afraid that me and anyone reading the Constitution carefully, you cannot agree with this decision, and it's going to cause confusion. And fundamentally, the court itself should not have been involved. Because let me go to another issue that they resolved. They said the budget was properly approved. That's they are holding on the third issue.
Yeah, the third relief.
I mean, what the third issue? Yeah, it's one of the reliefs, but they frame it as the third issue. I don't even know why a court is interested in answering this question, because it's a moot question. Whether the budget is approved or not approved, appropriations have been made already and people are moving on. So what exactly is the court doing by trying to say the budget was approved when the court does not actually consider the full set of facts? Because there were two approvals and the court is only talking about one approval. You have to understand the first approval before you can go to the second approval. You have to address whether the first approval was proper. If the first approval was proper, maybe the second approval was not even needed. You have to address the issue of whether, if the substantive speaker makes a ruling on an issue, the deputy speaker on another day can overturn that ruling. There are so many issues that require resolution before any serious person can say the budget has been approved or not. And in any event, it is a moot question. Why answer a question that has no consequence? The budget has been approved or not approved. Appropriations are being made. Any court will say this is moot. We don't have the full complement of facts. We are not going to get ourselves involved in this.
Let me ask you a final question on this. Now, my colleague, who's also a lawyer, sends in this one, and just your thoughts. Now, on Parliament Act 1965, Act 300, Section 14, that deals with voting, one says, subject to the provisions of this or any other act, or all questions proposed for decisions in the Assembly shall be determined by a majority of the votes of the members present and voting. And if upon any question before the Assembly, the votes of the members are equally divided, the motion shall be lost. Then 2, the Speaker shall have neither an original nor a casting vote, but any other person presiding, including a deputy speaker, shall have an original vote, but no casting vote. Now, on the Section 2, this is an act that regulates Parliament and perhaps addressed the issue at hand. What are your thoughts on that?
Well, I explained this already. This is, remember, the 1965 Act. Of course, an act does not control a constitution. And then, more important than the act that he sent, I also explained that even in the 1957 Constitution, what you just read about the deputy speaker was in the Constitution itself. So there is a history of that. And the fact that we've had this specific language in the Constitution and in the statute, this is what I explained. And also the fact that this specific language was proposed by the President Edward Akufo-Addo Commission. It was proposed in 1968, but the Constituent Assembly that ultimately framed the Constitution rejected that. It says, no, that belongs to 1957 and that belongs to 1965. We haven't had good experience with it. We don't want it. And that's why it is no longer in the Constitution. So this person bringing the 1965 Act is not showing anything magic. I've already explained that we had it in our Constitution, and having it in the Constitution is even more authoritative than having it in the statute in 1965 at a time when we had a one-party state. Clearly, a 1965 statute has no consequence for interpreting the 1992 Constitution. Beyond telling us that the framers knew about this architecture, considered it, and actively rejected it. And that is why we have had the Standing Order 1093 for 30 years, because all of the people in Parliament, they are very good lawyers in there. They know the rules. This rule has been there. One of the reasons they haven't touched it is because they know the history. And it's because they know that a person who is sitting presiding over other MPs cannot be partial. And one final point, you say some of the people say, well, it's not fair that our constituency is not being represented when we have a deputy speaker who is presiding. Well, go to the other constituencies. They are also complaining that it is not fair that an MP, an ordinary MP, would be making would be overruling their MP, because that's what you have, the power that somebody presiding has over other MPs. You are just an ordinary MP, but you have been temporarily elevated to act almost as a headmaster of the other MPs. Well, if I'm in another constituency, I can say, well, that's not fair. So that those type of arguments are not really legal or constitutional arguments. They are just thrown out there, similar to what we hear, rules are rules. When we had this Achimota case and people were saying the person cannot wear Rasta hair, then you hear all these slogans, rules are rules, and so on. Here they are saying Parliament is not above the law. Nobody is saying Parliament is above the law. All we are saying is that the Constitution should be properly interpreted with an understanding of the history and with respect to the words in the Constitution, i.e., read the part on the Speaker in conjunction with the Article 295 2A, which tells you a deputy is considered as a Speaker. And yes, if you look at the opinion, one mistake that is glaring is the court makes reference to the Kenyan situation. And it says in Kenya, the Speaker cannot vote, but the Deputy Speaker can vote. Well, wrong, because if you read the Kenya Constitution in totality, it tells you that the Deputy Speaker is treated the same way as the Speaker. So to me, again, I want to emphasize that the decision is very well written. I appreciate that, but the logic is totally flawed.